Let's start off with business and immigration law updates. This is a proud presentation of the Khurana Law Firm, where the Chief Attorney and Counselor at Immigration Law is Attorney Ramesh Khurana. Here on this set, Attorney Kenneth Haber asks Attorney Khurana on immigration considerations for corporate mergers, acquisitions, and restructuring. Let's have a look.
Hello, my name is Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney of the Office of Inspector General of United States Department of Health and Human Services. With me today we have Ramesh Khurana, a well-known immigration attorney, and this is the Capitol Forum. Ramesh, welcome.
Thank you very much, Ken. I appreciate you inviting me here.
It's my pleasure, and I'm sure that the viewing audience will find what you have to say most informative. Ramesh, can we get down to the nuts and bolts of this particular episode of the interview for you? We've heard a lot about globalization. We've heard a tremendous about globalization, and part of globalization is the acquisition and mergers of corporations, and they do that across the world nowadays. Little companies bought up by big companies, little fish swallowed by big fish. Can you explain some of the possible corporate risks that are involved from an immigration standpoint with these sort of international mergers and acquisitions?
Sure. Ken, you made a great statement because the whole world has become a kind of small village. Things are moving so much faster between different countries, and acquisition, mergers, now these have become the order of the business community. And I'm not surprised that when these mergers and acquisitions are taking place, some of the attorneys who are doing the corporate work, probably they don't speak with immigration lawyers, because there are always immigration consequences for the people who are on H-1Bs or L visas or E visas or TN visas, and even for those people whose green card applications are pending. Now they have so much at stake. You know, the moment they celebrate after the closings, like say, okay, we are closed, I would say at the same time, so many people who are not yet green card holder or citizens, now they are out of luck. They are losing their status. They become illegal overnight.
How is that?
Because, you know, they didn't consult with any immigration lawyer. They are supposed to be taking first step immediately after the closing before they start celebrations. That's the way I will put it.
Because they're no longer employed by the old employer, they're employed by the new employer.
Exactly. So that's the kind of analysis which is required to be done by the immigration lawyers. Some large corporations do have immigration lawyers within house, but they are so much busy in just filing thousands, hundreds of petitions. H-1B is going here, T1 going here. They hardly pay any attention. Or even though immigration lawyers are sitting with large corporations, I think those corporate lawyers probably don't talk to immigration lawyers. Like, what are your issues? We should keep in mind. But once you just do the closing, damage is already done, and this becomes irreversible. So my advice to all the corporations who are thinking of buying other corporations or doing mergers or spinning off or changing their addresses, please talk to your immigration lawyer before you do it.
It sounds like that there's a whole field of landmines out there that could occur because people don't take proactive steps.
I agree with you. I remember recently one of my clients' company that was taken over by a large company. And we had done several, I would say tens of green card cases, perm cases. And the new company which took over that said, sorry, we have to restart all these labor certifications one more time, because that was the advice which was given to them by their immigration lawyer. And these people were at an advanced stage. They had crossed 2 stages. Their application under the PERM or labor certification that was approved, I-140 was approved. They said, no, it doesn't meet with our requirement. Job situation has changed, job duties have changed, and we need to restart the case. Look at the situation. What would have happened to those employees who were at an advanced stage of getting their green cards and restarting the whole process?
Could there have been some way of continuing it with a change of owner notice?
Again, this was something which they should have discussed. It will depend upon case-to-case basis, and this was something which they would have warned those employees that this might happen. Whatever corrective steps you have to take, you should take. But I do agree, because these things are very confidential in nature. Whenever we are talking about mergers and acquisitions, probably they don't want to send out any message to anybody. And that's the reason probably corporate lawyers are not discussing even with immigration lawyers, because of strict confidentiality attached to it. So, but whatever, at least I think immigration lawyers should be taken into confidence, and that blueprint of the plan should be ready, like what is required to be done on the first day once the takeover is complete.
Are there things that the executives themselves could do for their employees to help them along in this regard?
You know, oh, definitely. If there is a proper plan in place and there are certain situations, it can be done. It can be done. You know, the key word here is the successor in interest. Like the company which is going to be a new employer for all these immigration benefit applications. Now, if it can be proven to the immigration authorities that the new employer is a successor in interest, then probably everything will be addressed satisfactorily. So that means when you say successor in interest, whether this is an asset purchase transaction, I say stock purchase transaction, but you have to show that you have taken over the liabilities of the company which has now extinguished, no longer exists, because it has merged or taken over, right? So if you have taken over the immigration liabilities and it is well documented in the corporate papers, because you cannot create these papers later. These have to be created as part of the agreement when you are taking over a company.
Part of the merger agreement.
Yes. So if you can prove this is a successor in interest, situation different. If you can't prove it, then this employee belongs to nobody.
Wow. All because they didn't plan.
Yes.
That's terrible.
Yes.
What's a TN visa?
You know, Ken, TN visa is trade NAFTA agreement created this kind of visa, which is available to nationals of Canada and Mexico, because they are holding nationalities of Canada or Mexico, and there are certain special professions which have been approved for the purpose of TN visa. Let us say the position of an accountant. If the person is holding a bachelor degree in accounting, and if this person finds a job of an accountant with a US company here in the US, this person can obtain a TN visa. And this TN visa is issued for a period of 3 years. Now, the question would be, what happens to the TN visa holder when the company has merged or no longer exists?
This is even more critical for Canada, United States, and Mexico, because the economies are so integrated.
Yes, yes. Now, in that kind of situation, the good point is, in case of H-1B, it's a little bit difficult in the sense because there are 2 departments or 2 agencies involved. One is the US Department of Labor, with whom you have to file the labor condition application. Before you can file H-1B petition with the Department of Homeland Security or USCIS, the labor condition application has to be certified by the US Department of Labor. So 2 agencies are getting involved. But in case of TN visa, there is no LCA requirement, so there is no role of US Department of Labor. And moreover, if the nationality, like you talk about international issues, mergers and acquisition, and if some company, let's say from India, is taking over US company, nationality changes, but it's not the nationality of the company which is important. Important thing is the person has the Canadian nationality who can be on TN visa. His nationality is not changing because of mergers or acquisition. So it's easier to handle TN visa applicant. If something happens, worst scenario, I would say this person can go to Canada with the job offer letter from the employer, maybe a new employer, because they got the new federal tax ID number, and he can present himself before the CBP, his Customs and Border Protection Force, and he can be interviewed and he can be stamped TN visa, which should not be a problem.
It's just because of the fact that they've got Canadian, U.S., Mexican.
Yes, it's much easier to obtain if the person qualifies with the eligibility norms.
Well, you know, I wouldn't want to insult any of our Canadian viewers, but we always used to, when I lived in Detroit, think of Canada as the 51st state, but I'm sure that they would not agree with that.
Right. Sure.
What are the L1 intercompany transfers about?
You know, L1 intercompany transfers, as you use the word, basically, this is about transferring an employee of a foreign company to the United States. Now, these two companies are interrelated. One of the companies is either a parent company or a subsidiary company or an affiliate. So, one of these kinds of relationships. Now, your question, what happens to an L1 employee? Now, again, the situation is very tricky because the basic criteria is that foreign company continues to be in business. So there has to be a tie between the US company and foreign company. And because of takeover and merger, if that foreign company is no longer in existence, then there could be a problem because that chain would be broken. But if that relationship continues, other things continue, depending upon what exactly is the situation, it will depend whether we have to file an amended petition or maybe change of location. So all these points have to be kept in mind in case of mergers and acquisition. But simply getting a new federal tax ID, and if it is a successor in interest company, then I think you can handle the situation very well.
Before we get a lot of hate comments concerning my comment about Canada, my mother was Canadian.
Okay.
We used to tease her that she came off the boat, the Detroit-Windsor Ferry.
Okay. Okay.
I'd like to thank you very much for coming on in and explaining all that to the viewing audience. I'm sure that they found it as informative as I have, and I'd like to thank you very much.
Ken, thank you very much for inviting me, and I also found it very interesting to answer your questions and advice to the audience. Again, as usual, if you have any questions, immigration is a very complex world. Please take help of your competent immigration attorney to answer your questions. Thank you very much for being with us. I appreciate that.
Thank you.